Hello everyone and welcome to this video tutorial on how to apply the law on occupiers liability. In this video tutorial we're going to be looking at a mini scenario on occupiers liability, this time the 57 Act. And I'm going to be running through with you the two approaches you could take to writing out your answer, both using the idea structure, but one using what I call standard idea, which we've used before, and another option being the EA idea structure, which you might find easier on an occupier's liability scenario. Let's start by looking at the situation that we've been given then. So Dave paid Tom, a roofing contractor, to replace the brick chimney on his roof. When Tom was replacing the bricks in the chimney, he used the wrong cement mix. As a result, some of the bricks came loose and fell on Jess, a postwoman, as she was delivering Dave's mail. Jess had noticed that the bricks were loose and might fall, but had decided to ignore this risk. And you're being asked to discuss Dave's liability in tort. Notice this particular question doesn't tell you it's an occupier's liability question. And that might be the case in the real exam. So in the real exam, they might give you the scenario and say, discuss Dave's liability in tort. Or they might say, discuss Dave's liability under the Occupiers Liability Act. Obviously, the second way is easier because it's telling you what it wants, but you have to be prepared to read the scenario and think, right, okay, what's the issue here? And hopefully you would have all spotted that that's clearly an occupier's question. As always, once you've got your scenario and you've read through it, as we've just done, you would need to highlight any issues in it that jump out at you as being relevant. And in order to do that, you need to cast your mind back to when we studied occupiers liability in class, think about all of the law and think to yourself, does any of that particularly stand out in this scenario? So I'll just skip back to the summary of the Occupiers Liability Act 1957, just to remind you of the key cases that we looked at in this area. So remember that occupiers liability is all about whether the occupier of premises should be liable for injuries sustained by the visitors. 57 Act is lawful visitors, 84 Act is trespassers. We're looking at lawful visitors today. So remember that your occupier is defined in Wheat and Lacon. Premises are going to include aircraft and vessels as well as houses, and that the common duty of care for a lawful visitor is to ensure that they're reasonably safe. There are some special situations listed in the 57 Act where you've got children visitors or professional persons, where warnings have been given, or where work by independent contractors has been done. And there are cases that we've studied that help to explain these rules. And there are also defences that you could potentially try and argue as well, such as contributory negligence and volenti non-fit injuria. So a little recap for you there, and you should be thinking about all of those things when we're looking at this scenario involving Dave. So the first thing that jumps out, hopefully, is this element here, that Dave has paid a roofing contractor to replace a brick chimney on his roof. So hopefully you're immediately thinking independent contractor here. And we've got the wrong cement mix. And then here I would be highlighting Jess. She's our unfortunate victim in this scenario. And she's a postwoman. That's relevant because that fact is telling you that she's a lawful visitor. She has implied permission to be on his premises to deliver his mail. She's noticed that the bricks were loose. Now that's relevant because that's telling you two things really, that this bad work by the contractor seems to be obvious to a normal person, so maybe Dave should have checked. And it's also telling you that she's seen this risk from the ground, she's chosen to ignore it, so could she possibly be volenti or contributorily negligent? So just by looking at this scenario, you can see here that the focus of this particular one is about independent contractors, and you're going to need to be applying that in your answer. So once you've worked out what the answer is, as we've just done there, you need to then write your answer out in a way that you're going to get maximum marks. And we always use the idea structure when we're using scenarios. but there are slightly different idea structures that we could use on this scenario. And I'm going to start by just running through what we call standard idea. This is the idea that you're all well used to using, and if you're totally happy with it and don't want to use anything else, by all means go for this. So I'll run through this one with you to begin with. Once we've gone through that, I'll then show you the alternative option and just have a look at it, see whether you think it's going to be helpful, make your life easier on this. So, standard idea that we're all used to: identify, define, explain, apply. So you would identify that Dave, who's our occupier, might be liable under the 57 Act for the injuries to Jess. You define what occupier's liability is. So I've said it's the duty owed by an occupier to those who come onto their land, and we've got the 57 Act for lawful visitors, the 84 Act for trespassers. And then you're going to explain all of the requirements of occupier's liability using essentially what we were just looking at, explaining all your key cases. And then the final step, you apply all of those requirements methodically in order to your character. On my next slide, I will show you just a bullet point answer using that standard idea. Again, just ignore the red ones that are on here. That's just when I've used it as a model answer in class. So I've identified Dave might be liable under the 57 Act for the injuries to Jess. I've defined that they must take care to ensure visitors are reasonably safe because Jess is an implied visitor. She's lawfully allowed to be there. And then I've explained the law. So I've explained an occupier, premises, etc. You'll notice I've included sections of the 57 Act. I've included cases. Mine is bullet points, but of course in your answer you're going to be writing in lovely full sentences. So I've identified, defined, explained, and then I apply it back. And you can see here that my E is acting as a checklist for what goes in my A. So in my E, the first thing I've said is that we need an occupier. And in my A, I've said Dave is an occupier because he owns or rents the house. I then in my E talked about premises. So in my A, I've then said that Dave's house is premises. So you can see that you're going through all of the elements. And I've talked about the fact that Jess is a visitor. She's got implied consent. I've then talked about the fact that what's relevant here, children aren't relevant, professional persons aren't relevant here, it's independent contractors. So I've pointed out Dave has employed an independent contractor, and the rule is he won't be liable if he took steps to ensure the independent contractor was competent and inspected the work if possible. Now, chimney, high up, and it might not usually be easy to inspect, but the fact that Jess noticed that the bricks were loose indicate that he should have inspected it, as in Woodward and Hastings. So he might be liable because he should have inspected the work. And what I should have also put there is that there's a possible defence of valenti. What you could argue here is that because Jess noticed she's valenti, she saw the risk, she accepted it, so Dave shouldn't be responsible. However, I'd be concluding here that I don't think it's fair in that situation. She's simply doing her job. She doesn't really have much choice because she's got to deliver his post. So I don't think it'd really be fair to find a valenti. So you can talk about the fact it could be raised by Dave as a defence, but it probably won't work. He should have inspected the work. He's going to be liable. So that's your standard idea. And you can recognise it because you've got a big chunky E and then a big chunky A. Now I want to show you how you could approach this slightly differently using what we call the EA idea structure. And it might be that you actually find this easier. And another advantage of the next structure I'm going to show you is that if you run out of time, let's say you run out of time when you're doing your E, you're not going to pick up any application marks because you've missed out all of your A. Whereas if you explain, apply as you go along, you're going to be picking up application marks. So if you do run out of time, you should have a nice mix of AO1 and AO2 points. So that's why really I'm showing you this alternative structure. On this slide then, I've got how you would apply occupiers liability using the EA idea structure. And I'm calling it EA because what you're going to see is EA throughout it. So when you're using this structure, you start off the same as you do for a standard idea. You identify your defendant and what they might be liable for. So Dave might be liable under OLA for the injuries to Jess. You define the tort or the area that you're applying. So occupier's liability is the duty owed by an occupier to those who come onto their land, 57 for lawful visitors, 84 for trespassers. So it starts off the same. And then I go on to my E and I explain occupier. But then I apply it. So using this structure, I explain an element, so explain occupier under section 1.2, wheat and lack on, then apply it to your scenario. Then explain premises and apply it to your scenario. Explain the standard owed and apply it to your scenario. Explain children, apply children. Explain professional callers, apply professional callers. Explain independent contractors, apply independent contractors. You get the point. So it's EA throughout. So instead of, and I'll just switch back to the other answer that we had. So instead of using standard idea, you have a big chunky E, you do no application at all, you apply at the end. What you see in here with this idea structure is you EA throughout. And as I've already said, the advantage of that is if you run out of time, you'll still have got some application marks. And another advantage is you're less likely to miss a point out, because if you do a big chunky explanation and then you apply at the end, you might forget to apply something you've explained. So this is actually quite a nice structure on occupiers liability. And I'll show you on the next slide what my answer would look like if I'd use this EA idea instead. So Dave might be liable, defined occupiers liability, I've explained occupier, and then I've said Dave is an occupier because he owns the house. I've explained premises, Dave's house is premises. I've explained the standard owed, Jess is a visitor because, so there's a duty to keep her reasonably safe. I've explained children, Jess isn't a child, so the standard doesn't change. I've explained professional callers, Jess isn't a professional caller. I've explained independent contractors, and this is where I'd give all my rules here because Dave has employed an independent contractor. I've explained warnings, I've pointed out that Dave didn't give a warning here. I've explained defences, I've said she's possibly Valenti, but I've concluded that it seems to be a bit unreasonable to find Jess Valenti, so it seems that Dave's going to be liable because he should have checked the work of the independent contractor. But here, what I'm hoping that you can see is that there are two approaches, and both approaches would get you full marks as long as you don't miss any points out. So using standard idea, if you are totally happy with that, fine. But this option, as I've said, has some real advantages in terms of timing and also making sure that you apply each element, you don't miss anything out. So I really encourage you to maybe have a go at this scenario using both idea structures, standard idea and then the EA idea, and just see which feels best for you. Both options, as I've said, would get you the full marks. So I hope you found that helpful in terms of how to apply the law on occupiers liability, and hopefully you'll be able to use both of those approaches, whichever you find easier.